Everyone's trickling in. Welcome. All right. We're getting there. Welcome, everyone. Okay, just watching the numbers tick up as we... Okay. Sweet. Okay, I think we're there. So welcome, everyone. I'm Catherine Klosek, Director of Information Policy and Federal Relations at the Association of Research Libraries, ARL. I want to thank you all for being here, and thanks to Authors Alliance for co-hosting this timely conversation as we're starting to see decisions made in the courts about fair use in generative AI. The Library Copyright Alliance put out principles on copyright and AI back in 2023, and we knew that litigation would shape the legal landscape for generative AI. And there is a lot more litigation pending in district courts, but today we're looking forward to hearing about the early decisions that we've seen so far and their takeaways for researchers, authors, and libraries from our expert panelists, including John Bam, who's copyright counsel for ARL and the Library Copyright Alliance, Dave Hansen, Executive Director of Authors Alliance, and Yuanxiao Xu, Staff Attorney at Authors Alliance. Thanks again to those who submitted questions ahead of time for the panelists. For all viewers, you can use, or viewing live, you can use the Q&A function on Zoom to submit your questions for the panel, and we're going to leave time at the end for discussion. So enough from me. Let's hear from our panelists. Yuanxiao, would you mind kicking us off by just summarizing the cases and maybe highlighting places where there was consistency in the cases and where the judges diverged?
Thank you. So thank you all for being here today. You probably have noticed these disputes over AI training are forcing us to ask some very big questions. Why do human authors create new works? And how do we advocate for these authors, especially the ones we're counting on to start creating in the future? As you listen and participate in today's discussion, I'd like to ask you to keep those questions front of mind, because the answers to these questions affect all current and future authors and creators. That is, all of us. So at the center of these cases is fair use, a proud tradition of US copyright law since 1841. Fair use is what allows scholars to quote books and artists to create parodies. It's a First Amendment right, designed to ensure that copyright serves human creativity instead of just monopolistic corporate interest. So now, two opinions handed down just 2 days apart have become the first court decisions on whether training general-purpose large language models, or LLMs, can qualify as fair use. Let's be clear first that these are summary judgments. They are early-stage rulings. That means the courts had to interpret disputed facts in light most favorable to the plaintiffs. And some of the judges' comments in the issued opinions are just their musings, not even holdings. For example, in Kadrey v. Meta, the market dilution theory was never even raised by the plaintiffs in their pleadings. And its 10-page long analysis, taking up 1/4 of the entire opinion, had no bearing on the judge's ultimate holding in the summary judgment. But even these musings matter, because how we interpret, critique, and respond to these musings will shape how copyright evolves for all authors and for the public. So I want to really thank Catherine today for convening this panel. These are exactly the kinds of conversations we need right now. I want to make sure we're all on the same page about what these cases are actually about. So I'll start by briefly explaining how large language models are trained, and then I'll walk through the two cases. When we talk about training a large language model, like Claude or Meta's Llama, we're referring to the process of feeding huge amounts of text to an algorithm. The model uses this text to detect patterns in language and predict what comes next in a sentence. The result is not a searchable database. What's produced is an LLM made up of numerical weights and parameters, a system that can generate language based on statistical patterns, not stored passages. Now, with that basic understanding in mind, let's look at the two lawsuits that are putting this process under legal scrutiny. The first case is Bartz v. Anthropic. 3 authors are suing Anthropic for using their works to train its cloud models. But they're not just suing for themselves. The court recently certified a class that could include millions of authors whose works were found in 2 shadow libraries, LibGen and Pillamy. Whether class certification on that scale is problematic is a question we can maybe discuss later. The second case is called Kadrey v. Meta. It involves 13 authors suing Meta for using their books to train llama models. Both of these lawsuits focus exclusively on the training of LLMs, not its possible outputs. So not the specific texts these AIs are capable of producing. The plaintiffs in both cases argue that the training itself is infringing, and that the training will eventually lead to a flood of AI-generated texts that indirectly compete with their original works. So now that we've covered the basics, I want to turn to what has probably gotten the most public attention in both of these cases, the allegations of piracy. You've likely seen headlines claiming that Meta and Anthropic stole millions of books. And here's what we know from the pleadings in these cases. In Bartz, Anthropic allegedly obtained millions of books. Some are pirated, some lawfully purchased, and then, according to the court, destructively scanned. And they used these books to build a massive internal library. From there, subsets were cleaned, tokenized, and used for model training. The court found it troubling that Anthropic couldn't confirm which of the 7 million pirated titles were actually used in training. From the judge's perspective, at least some of the copying may have lacked a fair use justification because they were never intended for training. What made matters worse for Anthropic is that it refused to explain its internal data usage during discovery. So the court didn't waste its time speculating what these pirated books may have been used, and just said there's no justification to say it's conclusively fair use. By contrast, Meta apparently used fewer pirated books, but worse for them, they uploaded these pirated books through peer-to-peer file sharing system. This is a whole different red flag. The Kadrey court speculated that Meta's action may have supported the piracy ecosystem itself, which could be relevant to secondary liability down the road. But here's what's important to stress. Piracy was not resolved in either opinion. No party asked the courts to decide whether the pirating was unlawful under traditional infringement theories. These questions remain open and will be dealt with later in litigation. So what did the courts actually hold in these summary judgment opinions? Despite the piracy concerns, both courts agreed that training LLMs on books, as the plaintiffs described it, is highly transformative. Piracy was not a factor in the fair use analysis, at least at this stage. Both courts rejected the idea that plaintiffs are entitled to a new market for licensing books specifically for AI training. No such market currently exists, and even if it did, the court said copyright law doesn't require transformative uses to be licensed. And crucially, because the plaintiffs failed to identify any concrete market harm, both courts held that training LLMs qualified as a fair use. The courts also remind us that the purpose of copyright law is not to reward copyright holders. It is to benefit the public by promoting the creation and sharing of creative works. But the two courts also diverged in deeper assumptions about the AI technology. On the value of AI, the Kadrey court takes a very bleak view. It describes LLMs as low-quality imitators that will displace less famous human authors and reduce incentives for future creativity. It portrays LLMs as capable of autonomously flooding the market without human supervision. The Bartz court, on the other hand, believes that LLMs will likely enhance human creativity, helping under-resourced authors refine their writing or explore new ideas. Humans remain central to the Bartz court's analysis. And on market harm, the Kadrey court proposes a very novel theory of market dilution, suggesting that AI might harm writers by flooding the creative market with countless AI-generated books. The Bart's court did not believe machine-generated content represented the kind of competition that copyright law is designed to prevent. If these cases make you feel uncomfortable, you are not alone. The discussion of AI training exposes some long-standing tensions that copyright law has failed to resolve. On the one hand, major rights holders like Amazon Audible, Disney, Netflix, and major academic publishers are pushing us toward a pay-per-use model, one that maximizes control, restricts access, and monetizes every interaction we have with a creative work. At the same time, tech companies are building these transformative technologies behind closed doors with minimal public oversight and no clear pathway for how the broader public might benefit from these tools beyond just being treated as passive consumers. And caught in the middle are independent creators, researchers, educators, libraries, and everyday users, the very communities that fair use was meant to protect. Yet much of today's policy conversation is focused on crafting profit-sharing deals between tech giants and major rights holders, a solution that does little to address the deeper structural problems. Instead, in my opinion, it risks entrenching monopolies and pushing actual human authors' voices further to the margins.
Thank you, Yuanxiao. I think that was really useful kind of table setting, and I think you gave us some really useful perspective about the cases, kind of what the courts actually said, kind of where we are procedurally, and the questions that remain open. So really appreciate that, and I'm sure we'll elaborate on these and other points as we go along. Turning to John, so some copyright lawyers have said that these two decisions don't change anything about the fair use doctrine that authors, libraries, and others rely on. So tell us then, what can authors, researchers, and librarians who support research and scholarship take away from these decisions?
Thank you. So I'd say at first, just as Yang Xiao was saying, that these are just two decisions out of more than 40 cases that are being litigated right now in this area. And they're also early phases, like they're on summary judgment, and there's a long way forward in both of these cases. And Dave will talk a little bit more about the class certification part in one of the cases, but it's, these cases are going to be appealed, and then they'll, I'm sure, there'll be petitions to the Supreme Court, and then it'll go back. There's litigation in this area is going to continue for a long time, and so these are two of the first cases, so everyone's focusing on them, but it's important that we don't get all worked up, because there's going to be a lot more coming down the pike. And at some point, 5 years or 10 years from now, we'll barely remember the names of these decisions, even though we're all so focused on them. I mean, what we'll remember is the name of the decision that, where the Supreme Court, or the several decisions where the Supreme Court ultimately tackles some of these issues and resolves them, and we will forget these district court decisions, unless these happen to be the cases that the Supreme Court decides. It's also important to remember that a major factor of how these cases ultimately get resolved is the position of the administration. And so far, it seems that this administration is generally viewing training and the issues relating to training as fair use. It wasn't explicitly stated in the AI action plan that came out last week, but then President Trump, in a subsequent speech, basically said, to the extent one can understand what he said, but he basically said that, basically training has to be a fair use. Doesn't make sense to have any other approach. And that will have an influence on the courts as they go forward. There's no question. I don't think that there's going to be a judge who's really going to feel like be responsible, or even the Supreme Court that will ultimately feel like they should be responsible for, sort of destroying this sector of the economy. Now turning to so there's a long way down, and so I'm sort of suggesting what these cases decide. That doesn't matter that much. Don't worry about it one way or the other. However, we have to deal with these cases until the Supreme Court decides. We're going to have to live with these lower court decisions, whether it's at the district court level or the Court of Appeals level. And so then there's 2 points I want to stress, and this gets to Catherine's question about fair use and so forth. Is first of all, again, it's important to remember these cases arose in the context of commercial AI firms, right? So it's Anthropic and Meta. And so the analysis likely would be very different if you were dealing with non-commercial players. So let's say a scientific researcher at a university, what they do, they should be aware of what's going on in these decisions, but I'm not sure they should necessarily worry too much about them because I think the analysis would be quite different, in particular with respect to the shadow libraries. So clearly, again, here, in the Bartz case, the court was very disturbed by the accessing of the shadow libraries and the downloading in the Meta case, less so. But I would think in both cases it would be different if you were dealing with commercial research, non-commercial researchers who were accessing the shadow libraries because they simply didn't have the budget to buy the books or buy licenses for the books, whereas and they were doing it for research purposes. So I think that that's important to stress. However, to the extent that you're going to have joint ventures between academic researchers and commercial firms, I would say, yeah, stay away from the shadow libraries. Because that's it's very, very risky at this point to to train on them. I would think, again, this is, if you're purely academic, maybe not so much of a risk, but if you're either commercial or a joint venture, it just seems that it's very risky to use the shadow libraries. And then the second point, but we're going to hear a lot more about that, and in particular in future cases, because quite a few of the commercial firms did rely on the shadow library. So we know Anthropic, we know Meta, OpenAI, all probably trained on shadow libraries. On the other hand, Google probably didn't because they have their own database from the Google Books case. But again, that remains to be seen. But I think we're going to hear a lot more about that in the future. And then finally, the market dilution point that we just heard about. So this is interestingly, again, there was a split between these 2 cases. Judge Alsup sort of rejected in the Bartz case, sort of rejected it, said this doesn't make any sense, as we just heard. It doesn't have anything to do with traditional copyright law, and even the Copyright Office, which sort of endorsed this market dilution theory, described it as a theory, sort of like uncharted territory, right? That this is a new theory, and even Judge Chabria in the Kadrey Meta decision, he sort of acknowledged, he said, yeah, this is uncharted territory, but so is AI, right? The whole thing is uncharted. We're making it up as we go. And so, he was saying that market dilution could be an appropriate theory. So we're going to be hearing a lot about market dilution going forward. I mean, I personally think that it is, I agree with Judge Alsup that it is very problematic from a traditional copyright perspective. I mean, this is not the whole point of the fair use doctrine and copyright generally is to promote competition with when you're not creating things that are substantially similar. But here, this is exactly this flooding of the market would be with things that are not substantially similar to the original work. That's what copyright, I mean, that's what you're supposed to be able to do. So the market dilution issue really, a theory really goes to the heart of that. And it's also, I would say, problematic in terms of, and even the Judge Chabria, who sort of endorsed the theory, he sort of talked about all the things that you would need to do to prove it, and he acknowledged that the plaintiffs in this case, meaning well-known authors, their works aren't going to be harmed. I mean, they have sort of like a brand. It's the harm is going to be towards the new people, the undiscovered people, and it seems to me that that's just completely speculative, and how you go about proving that is going to be impossible. And it really, and this goes to, sort of what Yuanxiao's point at the end of her presentation is like, there's a lot of issues here that ultimately have nothing to do with copyright law, fair use. I mean, these are going to be issues relating to, uh, uh, what are, cultural heritage and cultural promotion and our cultural policy, things that really go way, way beyond copyright law. And maybe it's going to be important in the future to have more funding for young authors and young creators. Could be hard to imagine. Certainly, this administration and other administrations really funding that kind of thing, but that might be the what we really need. But again, copyright is not a should not be used in place of a cultural policy or a policy of promoting culture.
Well, thanks, John. I think you maybe help bring the temperature down a little bit and remind us that, these cases have a way to go. And I think you touched on some, practical takeaways for our audience as well. So appreciate that. Dave, would love to hear from you. So I know you've written about that getting a court to certify a class is a big deal. And so what does it mean that Judge Alsup has said that authors can bring a class action in the Bartz case? Tell us about that.
Sure. Thank you. And thank you everybody for joining. I was really pleased to see how many people are on the call. So what I thought I would do is give you like a short primer on class action law, which don't fall asleep on me. It is a lot more interesting in these cases than it might first appear. And it's really become a prominent issue, this issue of a class being certified in the Bartz case, because the judge has already put his stamp of approval on that. So lots of you have probably heard about class actions before. The idea with a class action is that you can have a small group of plaintiffs who sort of represent a larger group of people who are similarly situated and similarly harmed by some action that someone else has taken, so they can sue on their behalf. Lots of you, for instance, probably own a car that at some point has been subject to a class action lawsuit where the manufacturer did something that was wrong and they had to go fix it. And rather than having everybody who bought that car bring a separate lawsuit, there's this mechanism in the law that allows for a handful of people to bring that suit on behalf of everyone and then bring that issue to resolution. So that's the kind of basic function of a class action. And so one of the things that we've seen across a number of these AI suits, there are over 40, as John said, over 40 that have been filed, and a large number of them are class action lawsuits. And they're mostly being brought by a handful of writers or other creators, along with law firms that are very experienced with class action lawsuits against some of these big technology companies. Um, None of them have really progressed to the point of deciding whether those small group of creators can actually represent the whole body of other copyright holders that they claim, except for this Bartz lawsuit. And this Bartz lawsuit is a real unicorn compared to most of them. It was not filed that long ago, relative to the timeline for many of these other cases. Bartz was filed in August of last year. And we are less than a year into this suit, and we've already got a decision on summary judgment on the fair use issue, and we already have a decision on whether the class representatives and the class should be certified. A year may sound like a long time, but that's like lightning fast compared to the speed that all of these other suits have gone. And and it's caused some real problems, I think. I have a lot of criticism of how this suit has progressed because I don't think it's really allowed for adequate development of the facts or information needed to really certify the class in a responsible way. So that gets us to what has actually happened here. About a month and a half ago, or a little bit more than that, I guess now, the plaintiffs in this suit said, we're asking the judge to certify the class, meaning that we are officially, the plaintiffs in this case are officially allowed to represent all of the rights holders who have an issue in this suit where Anthropic has trained on their books. And as Yuanxiao has talked about, those books came from a number of different places. Some of them came from sources like LibGen and how did you say it? Pylami? We were debating how to say this other data set, but another kind of shadow library pirate site. And then some of the books actually Anthropic purchased copies, scanned them, and then used them for AI training. So in Judge Alsop's decision in this case, he sort of separated the analysis and said, if you're training, particularly using those books that were purchased and scanned, A-OK, that looks fair use, like fair use. But if you're just kind of accumulating a central library is the term that he used. I don't love his use of the term library there, but this central data set of books obtained from LibGen and this other shadow library, and just kind of holding on to it just in case, which is what it appears Anthropic did. They were holding on to these contents, presumably for future research and development or future work on their models, but they were just holding on to it. That's where the court said, I can't grant summary judgment on that yet. Technically, that's still got to go to trial, is what it looks like. But all indications from the opinion are that the judge really does not believe that that use is fair use. So what happened is the court then certified this class and said that the class includes all beneficial or legal copyright owners of the exclusive right to reproduce copies of any book in the versions of LibGen or Pylami downloaded by Anthropic. And so that's if you sit there for a minute and you think about what is in these data sets, there's about 7 million books represented in these data sets. And the judge has now pulled in all legal or beneficial copyright owners. That means people who actually are the copyright holders or people who get royalties from an exclusive licensing deal from those works. All of those covering about 7 million books. And he certified that that class could be represented by 3 authors: Andrea Bartz, who writes thrillers; Charles Graeber, a nonfiction author who wrote books like The Good Nurse and The Breakthrough, published by Hachette; and a third author, Kirk Wallace Johnson, who's a nonfiction author as well. And those companies, what's known as their loan out companies, where they essentially just hold rights on their behalf. So those 3 authors in this suit represent essentially now the entirety of the publishing industry. And that includes academic authors, that includes university presses, that includes probably some libraries that hold rights that they've, inherited or been gifted from authors. And so those three authors represent them in bringing the rest of this suit to trial, and potentially a judgment against Anthropic, or what is more likely to happen if this class certification stands, is that they'll try to work out some sort of deal with Anthropic. And that is the reason I think that's likely is because the level of damages that are at play in this suit are so astronomically large that with a class that's certified of 7 million or so books, and copyright statutory damages, which could be as high as $150,000 per work infringed, you're talking about billions and billions in potential liability. And so, from Anthropic's standpoint, if they allow that to go to trial and it turns out very badly, that's the end of the company. They go bankrupt. They just have no capacity to handle that kind of liability. And so this decision could also mean that those class representatives, now representing again the entirety of the publishing industry, are going to try to negotiate a settlement agreement. So I have lots of criticisms of this. I mean, one of my main ones is that it's really troubling and really impossible, I think, for those three authors to adequately represent the interests of this broad of a group of creators and rights holders. They just have very, very different interests. I mean, if you talk to academic authors, for instance, I think many of them will have a very different perspective, even on the very basis of the suit. For instance, the class includes many books written by AI researchers, like text data mining researchers, who rely on the very same fair use rationale that Anthropic has asserted in this case. So that's one issue. Another issue is there's no real common set of issues. Like, it's virtually impossible to identify with any level of precision all of the rights holders of these books. The closest analogy we have is the Google Books lawsuit from about 10 to 15 years ago. And in the midst of that suit, Google attempted to kind of craft a mechanism to identify rights holders and clear rights. And at that time, they indicated they thought they were going to have to spend, I think it was $34 million just to set up the organization to kind of do that rights clearance work. So it's very expensive, very complicated. Congress has tried to resolve this issue in a number of cases with orphan works legislation. The Copyright Office has studied it. So lots of people have looked at this rights identification issue and found it like very, very complicated and difficult. And the class certification that we have here just sort of glosses over it as if, you just send out letters and post notices on the internet, and that will resolve all of these issues. So that's the class certification issue. One thing I will note procedurally to keep an eye out for is that the class was certified, let's see, not last Thursday, but the Thursday before. And Anthropic does, under the Federal Rules of Civil Procedure, have the option to petition the Ninth Circuit for an appeal. And this is a appeal that kind of happens midstream in the suit. They don't have to get permission from the Judge Alsop in this case, but they do have to persuade the Ninth Circuit to take that appeal. And I note that because the deadline for that is coming up very quick. They get basically 2 weeks to file such a petition for appeal to the Ninth Circuit. Given the stakes here and what kind of liability this could mean for Anthropic, I would put the probability is high that they would try to attempt such an appeal to get the Ninth Circuit to do a quick look at this class certification issue to see if they will unwind it.
Dave, thanks for unpacking that. I mean, I'll speak for myself. I usually think of like sort of like pharmaceutical cases or whatever when we talk about class action. Obviously, there's a lot more at play here. So really appreciate you explaining that. Just to note, we did get a bunch of really good questions in. So maybe we can do our next round of prepared questions as a little bit of a lightning round, and then we can get to some of those audience questions. So Yuanxiao, back to you. The Kadrey court invoked the theory of market dilution. A few of you have already brought it up on today's webinar. So so. And we heard about it in the US Copyright Office report as well, the third part of their report on copyright and AI, which was released as a pre-publication. Can you just talk about that theory, explain it a little bit, and specifically why it can be problematic for research and scholarship?
I can't follow your instruction on a lightning round. There are so many problems with this, and I think we really need to pay attention to this. So first of all, we have been throwing around this word market dilution. What does it actually mean? So it's actually a brand new concept, coined only this year. We see it first in the US Copyright Office report and now in Judge Chabria's Kadrey decision, both using it to suggest that training AI models might fail the fourth fair use factor, which asks whether the use causes harm to the market for the original work. Traditionally, that market harm factor has focused on cognizable market harm, meaning direct substitution. So if I publish a book that lifts large parts of your book and people started buying my book instead of yours, that's clearly problematic and not a behavior we want to encourage. That's a clear market substitution. But market dilution stretches that logic very thin. Judge Chabria puts it this way. Even if the AI-generated work isn't a copy, if it's similar enough in subject matter or genre that it competes with the original, then that's still enough market harm because it indirectly substitutes for the original. As a favorite example repeated both by the Copyright Office and by Judge Chabria, if a reader buys a romance novel written by a LLM instead of one written by a human author, that's substitution. That's the essence of the market dilution theory, and as you can see, it dramatically expands the monopoly power copyright holders could claim. Honestly, when I first saw this, it made me wonder if public libraries were invented today, would Judge Chabria see it as market dilution too? After all, libraries present millions of books to readers and arguably reduce individual book sales. Would that be enough to claim market harm? Judge Chabria admits that market dilution is a novel theory and that he's developing it specifically to address AI. What he doesn't admit is how deeply flawed and dangerous this logic really is. So there are at least 4 unfixable problems with this theory. First, many AI-generated works actually incorporate human authorship. It's weird that this market dilution theory treats LLM-generated works as if they're machine-only creations, when in reality, many involve substantial human input. Books and essays created with the help of LLMs are often the result of carefully crafted prompts and multiple rounds of human refinement. These are not generic outputs auto-generated and uploaded for sale. To call such a work a substitute for an existing work is misleading. In many cases, what we are looking at is a new kind of creative process. Market dilution theory ignores this nuance and reality. It proposes to regulate human creativity not because the expression is potentially infringing, but simply because an AI tool was part of the creative process. That's not protecting the future of human authorship. It's penalizing up-and-coming authors who want to leverage new technologies. And second, this market dilution theory ignores the law. To prove copyright infringement, the law requires substantial similarity in protected expression, not just theme, tone, or genre. Yet market dilution places liability on the AI model even though the model is not substantially similar to the books. So the model is not even prima facie infringing, but is still treated as harmful under this market dilution theory. In essence, proponents of market dilution theory are trying to rewrite copyright law, sidestepping carefully balanced rules to create a new form of liability for AI developers without statutory backing. And thirdly, market dilution imposes impossible evidentiary burden on AI developers. The Kadrey court says AI developers can only escape liability if they conclusively prove their model doesn't now and will never in the future cause any decline in sales of a plaintiff's book used for training. That is just outright impossible for anyone to prove conclusively. So let's imagine for a moment that is not what Judge Chabria actually meant, even though it is what he says in his opinion. Another more concrete guidance for this kind of evidentiary showing needed is as follows. So I quote directly from his writing. The proper comparison isn't to a world with no LLMs, but to a world where LLMs weren't trained on copyrighted books. So that sounds more manageable until you realize what it means in practice is that every time an AI company is sued, it must be prepared to produce a control model trained only on public domain material for comparison. This alone can create a legal environment where only the richest players can afford to participate. Startups and independent researchers will be priced out entirely for this duplicative effort required. And lastly, and most egregious, I think, is that this market dilution theory only serves a few already successful authors and big rights holders. Market dilution presents itself as protecting the incentive to create. Judge Chabria also expressed deep concern for lesser-known authors, the writers he says the most vulnerable, as John already mentioned. But who actually benefits from applying this market dilution theory? Only those who can, one, afford to hire economists as testifying experts at around $1,000 an hour to produce very fact-specific reports, and two, to show quantifiable loss of sales tied directly to the use of their work in AI training. In other words, the beneficiaries of this theory are not emerging writers and definitely not future authors. The very human creators and human creativity this theory claims to protect will have no use of this theory. And let's go back to the romance novelist example. What is her best path forward under this market dilution theory? Should she try to trick Meta into using her work for training and then sue them for lost sales? Or should she aim to write books specifically to be licensed to AI companies for training AI, since Judge Chabria thinks that AI will inevitably crowd out her market? It seems to be the only realistic redress market dilution proposes. But is that the kind of creativity we want copyright law to promote? Market dilution is being sold as a way to protect the public and empower authors. But it's like so much in today's copyright discourse, including things like the No Fakes Act. It's a Trojan horse. It promises to protect everyday creators, but only delivers profits to a handful of very selective groups of people. So to conclude, unless you are a copyright lawyer, an expert for hire, a super successful and established author, a big rights holder, or a rich tech company, you really have no reason to like this theory of market dilution.
Thanks for explaining that so clearly. And I think hopefully when we all, see or hear that term, we'll have a better understanding of what it means and maybe our ears will perk up a little bit. So thanks for breaking that down. John, over to you with a question about legislation, calling a little bit of an audible. You were going to talk about the relationship between these cases and the recently introduced AI Accountability and Personal Data Protection Act. And I think, we definitely want to hear about that. But there's also a question in the chat about whether the president's remarks in the recent White House speech that you mentioned maybe give us an opportunity to codify, that training generative AI models on copyrighted works is fair use. So love to hear your thoughts on kind of the future and prospects of potential legislation in this area and on the bills that have been introduced so far.
So with respect to the Holly bill, it's completely unrealistic. It is so sweeping that you could never have any sort of generative AI whatsoever, whether it's from a commercial entity or a nonprofit. It's just the way it's worded. It would just be so broad. And it is sort of the latest in a succession of bills. In the last Congress were many bills that would, sort of talking about transparency, requiring AI developers to, keep records and disclose what works they trained on and so forth. And all of them really, would have the effect of narrowing or restricting the ability of new entrants in the field and end up basically, in a world where, as a practical matter, you could have Google and Meta, they'd be the only ones who could afford it. And, smaller, newer companies like Anthropic or OpenAI, they can't do it. And certainly academic researchers, they can't do it. It would just be Google, Meta, and I guess Microsoft. Uh, and that's probably not a great result from a public policy point of view. Now, the question in the chat was sort of like, okay, let's go the other direction. I mean, maybe now we could codify this and codify some of the decisions, or of course we only have parts of, you have these two decisions which are sort of at odds, coalesce in some respects and go in opposite directions in other respects. And, even to say, okay, well, you would never get agreement on which parts would you want to codify, even of these two decisions. And as more time passes, there'll be more decisions that will be going in other directions. And so, yes, I suppose you could imagine a world where the president basically says, okay, this is what I want. And then all the Republicans would fall in line. And then they'd need to get, just a handful of Senate Democrats. And maybe they could, but given the politics, I would think that anything that you would have to, with copyright legislation, as a practical matter, you need to get to 60 votes in favor. You'd have to get across the filibuster threshold. And I just, even if you could conceivably convince, I guess 11 or, about, 9 or 8 or 9 or whatever the number of the Democrats on the merits, I think just as a matter of principle, they would oppose it, right? So it's one can talk about it, but I just don't see as a practical matter that will ever happen. So at least at this point, we're going to have to just continue the slog through the courts. And I think ultimately it will, because they have faith in the courts, at least on copyright matters, maybe not in other areas, but in copyright matters. And I have faith in fair use. I think ultimately we'll end up in a good place, but it's going to take a while. And along the way, you're going to have, there'll be certain issues which might be problematic in certain areas. For example, the shadow library problem.
Thank you. I do love the way folks are thinking though about advocacy on this and where there might be opportunities and whatnot. I want to point out that some of the questions are being answered in the Q&A itself, and I also think for some of these we could maybe summarize them and maybe provide written answers afterward, perhaps. I also wanted to note that one of our questions was going to be around how folks can, stay up to date on all these cases, but Rachel asked a related but better question around sort of what types of resources we can develop and share to facilitate conversations with scholars. So I think maybe that's something we can think about and work on, maybe some, talking points for librarians or takeaways from the cases that you can use in those conversations. So if folks have, thoughts on resources or support that would be useful, definitely let us know. But I think that sounds, that's a great suggestion. And going to keep it rolling with questions from the audience. Dave would love to take a crack at this one. Libraries and librarians share some interest with big tech and with content creators. And on copyright, we've historically, or we often align with big tech, but AI raises a number of other issues, which Yuanxiao and John and Dave have really raised already. So what are the key points of difference between library interest and big tech in copyright and those other policy areas? What might those areas be, Dave?
Sure, I'd be happy to answer that. And on the resource question, my first thought of what to do there is to ask Rachel Sandberg for her help to draft those things. So I thought this was a really interesting question. I wanted to answer it because of the way it was framed. And I do think that often it feels like the library community and sort of the community of authors who really cares about sort of the public interest, we have to go and pick a side, right? And it's like, do we care about the authors and creators and copyright holders today, or are we aligning ourselves with big technology companies? Because, you know, they seem to be driving a lot of the narrative around what happens with policy here. And I get why that happens, but I think that, you know, from our perspective, or at least my perspective, what I really care about is the ability of people to continue to create, to continue to do research, uninhibited by over-aggressive copyright law and other laws, while also maintaining the ability to continue to actually publish those things and have them distributed. And copyright is an important part of that ecosystem as well. And as I'm looking at this space, I think one of the things that gets really lost in here is we have these lawsuits that are against some very big companies, Meta and Google, and OpenAI, which is backed by Microsoft. Anthropic is actually like the smallest of any of these. They have a market cap of $60 billion, which sounds really big until you compare it to some of those other companies. And the reality is that if if we have a future that demands licensing for access to every single work for AI training, the only companies that benefit from that are the companies that can afford to either purchase those permissions or just obtain them in other ways. I mean, remember, some of these companies, Meta has millions of users who upload content for free every day that Meta is training on. Google has an incredible wealth of content being voluntarily given to it by users every day. And Google says in their terms of service, they can use that to improve their services and improve their products. Presumably that includes with AI as well. So if we think about what these very, very large companies with ready access to licensed permission content and the ability to pay for additional content, if we think about that kind of environment, then I think it really behooves us to say, okay, great, they can do some of this, but we probably don't want to live in a world where only those companies can do this. We want researchers to be able to engage in this space, and we want startup competitors to engage in this space. And so I think that aligns us not so much with big tech, but with freedom to research and fair use. So I guess what I'm doing is sort of rejecting the premise of the question and saying it's those principles that I think are important to us. And if that happens to align with some of the positions that some of these tech companies are taking in litigation today, so be it. But I think it's a much longer term perspective that we're taking.
And Yuanxiao, thanks, Dave. And Yuanxiao, you added some thoughts on this in the Q&A, but please elaborate.
Yeah, I wanted to add a concrete example on where big tech and the research community, the library community may differ greatly, which is open access. So the big tech, they have pretended like they're releasing a lot of models under open access structure, but what they are actually releasing are just the parameters and weights of a finished product. And no human, no matter how great a programmer you are, can make sense of those weights and parameters of a trained AI model. So you're just looking at nonsensical numbers, numerical sequences. And there's nothing you can do as a researcher to make sense of how an open model like Llama can be used or can be fine-tuned further based on that information alone. So a true open access model would at least include what training materials have been used and how the fine-tuning was done. So the research community, in order to exercise more oversight and to control the kind of responsible AI that can be produced, would want to advocate for true open access models.
Thank you. A participant has pointed out that in fact the audience cannot see the Q&A or the answers. So I think what we'll do is we'll share the recording and transcript out with everyone who registered, along with the questions and answers of the questions that have been answered. Oh, okay. Some might be able to see them and some cannot. Conflicting information. Either way, we'll make sure everybody has all of the information that has been shared here. Okay. Sorry. We are running out of time and we have a lot of questions to get to, but John, did you want to speak? We had a question that was submitted ahead of time about whether these decisions impact the potential for publishers and authors to receive compensation for their works. Do you want to touch on that? That seems important.
Sure. So the authors and the publishers can always receive compensation, meaning there are currently licensing arrangements underway, and those are going to continue regardless of how these fair use cases come out, and even the nuances of is it a shadow library or is it just on the open web, which is again a critical distinction. But there are all kinds of reasons why, again, a large commercial firm would want to enter into a licensing arrangement, in part because even if arguably, or again, it's going to take 10 years or more, I would say, to know for sure what is fair use and what isn't fair use. And so if you have the money, why wouldn't you enter into a licensing arrangement with a few publishers who you think have useful content, and you want to train on their materials? Also, there's training and there's training, and you have pure training, but then you also want, what happens if you want to use expression in the outputs, which could be very, very useful. Certainly, you're going to want to enter into a licensing arrangement with a publisher whose work you're going to want to incorporate in your outputs. For example, the New York Times. I am confident that the New York Times is it's litigating with the AI firms. But the point is, before they filed litigation, they were trying to work out a licensing arrangement. They couldn't work it out, and so the American solution to that is you file suit. And now I'm sure they're still talking, and I wouldn't be surprised if they will ultimately reach an agreement, or at least the New York Times might reach an agreement with one company, and they will then make a lot of their content available not only for training but also for use in outputs, because that's what the companies really want to do, right? I mean, you want to be able to, in your results, say the New York Times says such and such about the so-called agreement on tariffs between the US and the EU, which of course is not really an agreement. It's an agreement to agree at some point in the future with details to be worked out. But you're going to want to be, there's going to be a desire to be able to include those, not only the facts but also the expression, and so there's but again, you don't need to do that with everyone. Maybe just the New York Times or just a few newspapers or a few other publishers. So certainly there'll be a desire to include the expression, and so even if the training issue aside, there's a lot of opportunities for licensing.
Thank you. We have less than a minute left, so I will wrap us up. Unfortunately, that went by really quickly. I really appreciate all of the expertise that was shared here, and I'm really excited by all the questions. So I do want to make sure, like I said, we'll make sure to share those out, and you will hear more from Authors Alliance and ARL on these cases and these issues. Thanks again for your attention, for your expertise, and yeah, more to come. Thank you.